Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend and special guest, Russ Cook with Russ Cook & Associates in Brentwood, Tennessee. Russ is a board-certified estate planning attorney and been in business like over 30 years, right?
Yeah, wow. Yeah, a long time.
There you go. So I've known you about half that time, in fact, and we've been working together with clients for a good 15+ years. And we've done, I mean, we've gone to into people's homes when they're on their deathbed and stuff like that to actually get documents done. Don't wait that long.
Yeah, please. Please.
But we've, so we've been through and seen a lot with different clients, and including the administration of estates when they're, or of trust basically when they've passed, and the kinds of things that we run into with the families. And one of the things that's nice with when you put together a good plan, and the families, when I'm working with the children now who have inherited money and it's come to them in trust, and they see all the value of what that's what it's doing for them, how it's protected them, they're thrilled, and typically they become clients as well, and we end up doing expanding out that estate planning to encompass the rest of the family, if you will. One of the things, Russ, you're talking about new tax law and some of the benefits that have been there. One of those is not just when it comes to IRAs. This is one of those areas I'm going to have Russ talk a little bit about, because IRAs, when your own retirement accounts, you've got certain protections with, but when you leave that money, all right, to a non-spousal beneficiary, in other words, when it goes to your children, as an example, or grandchildren, that protection for them is no longer there. But there is a way you can still protect them, right?
Yeah, getting back to the beneficiary controlled trust that we discussed before, if the estate plan that's put together creates those trusts, then we can name those trusts as beneficiaries of that retirement account, and that is very important. Sometimes we'll run into clients who have named their estate as a beneficiary of their IRA, or maybe they've named a revocable trust generically, and that might create a tax issue because the person who is handling the estate or the trust initially then may be forced to take the money out and pay the tax on it. We don't necessarily like that. So what we'll tell clients is, if you want to protect this inheritance going down to your kids, and the court is very clear that once the assets pass from you to them, it no longer has the same protection as it did when you owned it, then you want to make sure these trusts are created in order to receive those benefits. And they have to be the type of trust in which you can look through the trust to the child in order to determine the measuring life, the RMD they call it, payout, because you don't want to force us to have to pull money out of that retirement account any quicker than the child's life expectancy. So as long as those issues are resolved, then you've got something that's bulletproof to handle those assets, and you don't have to worry about child creditors going after them.
This is one of the areas. So we want the asset protection, but we don't want to give up the tax benefits, which means, so RMD, required minimum distribution. This is what the IRS requires at age 70 and a half on your own retirement accounts. You have to then start taking that money out. Otherwise, there's a 50% penalty. If you needed to take out, I've got clients that are, have 6-figure RMDs, required minimum distributions. Now imagine you're supposed to take 100 grand, you don't do it, and you got a $50,000 penalty. Ouch. Okay, so we don't want to do that. Now what do you do there? All right, this is one of the areas with required minimum distributions. It's real important, one, that we take them. Well, here's one of the things. If it's an inherited IRA, right, you don't get to wait till age 70 and a half. It's the year after the year in which you inherit that you have to start taking those required minimum distributions, no matter what your age. Even if a child, if it was left to a grandchild, they could be a minor, and they still have to take those required minimum distributions. The next thing is making sure, and this is so important, the quality of your documents, okay? It's making sure the language is in there that deals with that IRA, so that it's giving the ability to stretch it out, allow that person to just take the amount that the IRS requires. In other words, just the minimum distribution required by law. That's what we want in there, so that they have the control. Now, if they want to take more, they can always take more, but at least they're not forced to. And if the language isn't in there correct, they may have to, liquidate that in as few as 5 years without any choice in the matter. They just have, the 5-year rule may come into play, and they've got to take it out within that time frame. That could create some really heavy tax burden in terms of paying a lot more in tax on that account, on that asset, than they would otherwise if they were able to stretch it out and control it more. And being able to control it gives you the ability to say, well, I can take this little bit out, or I can take a bit more, and we'll look at what their tax bracket, and we'll find ways that we can take it out to minimize taxes over time. That's one of the areas when it comes to retirement accounts, right? You're building up these accounts, these IRAs, 401ks, whatever it might be. You're building these up to retirement, and when you start taking money out, it's fully taxable, and it's at the highest income tax rates. No qualified dividends, no capital gains rate, highest ordinary income tax rate. So if you're up in you could be in a 22, 24, or higher bracket that you're going to be paying tax on, and for a married couple that's at making up around 100, 103, 104,000, you'd only be in a 12% bracket. So imagine you're almost doubling your tax all on how you take it out. So if you're forced to take more than you want, and it pushes you into that higher bracket, you just doubled your taxes on an asset you could have paid half as much on. So that's one of the areas with planning when it comes to the documents that you have, making sure that they're done correctly. And this is one of the areas, Russ, that too many times people come in thinking they've got something that is going to do with asset protection being one of those. I've had a number of times where clients have come in saying, oh yeah, that's in there. And I'm looking and I'm saying, I don't see it. Yeah. And I'll send it to you, and same thing. That's not there, and it's such an easy fix.
It is an easy fix, and that's why it's important to make sure you have your documents looked over on a periodic basis, whether hopefully by someone that is qualified to be able to review them. I'm not pitching me, but I'm just saying someone that does estate planning, because these documents can be very cumbersome and time consuming to review, and I wouldn't necessarily want to look over it and try to figure out what it says if I didn't know the law and how it plays out. So that is very important, and we have had cases where people come in with documents that definitely don't do what they want them to do, and luckily nothing's happened and we don't have to worry about it. And we've had those cases where documents are presented to us after someone's died and we're like, oh gosh, this is not going to work out. We're going to have to figure out how to fix it, and that's very expensive.
Yeah. Yeah. As with most things, when you do it up front, when you catch your own mistake, so to speak, this time of year, required minimum distributions is one of those. Making sure that that's been taken out, and if it's not, correcting it as quickly as you can, fixing that before the IRS does, send you that nice letter. You want to fix that. You present it any time so far, fortunately, when we catch things like that, when a new client's come in for the first time and they haven't had that, didn't take their RMDs, we get that fixed for them, we get those monies out of the IRA, we notify the IRS that we've fixed the problem, how it occurred, and how we're going to make sure it doesn't occur in the future. And so far, they've been really good about waiving penalties when you fix the problem yourself, okay, as opposed to them finding it and coming back. Then it's so much harder to get them to waive that 50% penalty. So required minimum distributions is one of those areas, and understanding how the rules work and how you can use them to your advantage, and making sure that your documents, your estate planning documents, are going to do what you want them to do, and not just when it comes to when you pass away, protecting your family in the way that's done, but also maybe you come incapacitated. There's how those documents can also be of value to you, and setting up who's going to take care of your stuff for you in that situation, and take care of you, and you get to pick that person, as opposed to having to go to court, having a conservator appointed. And we're going to get into this a little bit, because this is another area that people don't realize just how cumbersome that can be if you have to go to court and have a conservator named simply because you didn't have, say, a power of attorney document, or even better, having both the power of attorney and a trust document together. That's going to give you even more control in terms of how those assets are handled for you and taken care of for you and for your benefit during your lifetime. All right, but first we got to take another break. So join us here. We'll be right back on the Retirement Report.